Pleading. The term pleading refers to the formal written statements filed by parties in a legal case, where they outline their respective claims, defenses, and arguments. Pleadings are crucial in the legal process as they serve as a means for parties to present their positions and establish the issues to be resolved by the court. Let's take a closer look at the different types of pleadings and provide examples of each. 1. Complaint. A complaint is the initial pleading filed by the plaintiff, the party bringing the case, to commence a lawsuit. It sets out the facts of the case, the legal basis for the claim, and the relief sought. For example, the plaintiff alleges that the defendant breached the contract by failing to deliver the goods as agreed, resulting in financial losses. The plaintiff seeks compensation for the damages suffered. 2. Answer. An answer is the responsive pleading filed by the defendant to address the allegations made in the complaint. In the answer, the defendant may admit, deny, or claim insufficient knowledge to respond to each allegation. For example, the defendant denies the plaintiff's claim that the contract was breached. Furthermore, the defendant asserts that the plaintiff failed to fulfill their obligations under the contract, relieving the defendant of any liability. 3. Counterclaim. A counterclaim is a pleading filed by the defendant in response to the complaint, where they assert their own claims against the plaintiff. It allows the defendant to seek affirmative relief from the court. For example, the defendant counterclaims that the plaintiff's negligence caused them physical and emotional harm. The defendant seeks compensation for medical expenses, pain and suffering, and any other damages deemed appropriate by the court. 4. Reply. A reply is a pleading filed by the plaintiff in response to the defendant's counterclaim. It addresses the allegations made in the counterclaim and may assert additional defenses or claims. For example, in response to the counterclaim, the plaintiff denies any negligence on their part. Furthermore, the plaintiff argues that the defendant's injuries were not caused by their actions but rather by their own negligence. These are the primary types of pleadings commonly used in legal proceedings. Each serves its purpose in presenting the parties' positions and shaping the issues to be decided by the court. It is important to note that the specific rules and requirements for pleadings may vary depending on the jurisdiction and the type of case being pursued.